Rules of evidence. There are standards of evidence, rules, principles that you can learn to make more persuasive arguments, give future employers reasons to hire you, determine the truth of a matter, convince your girlfriend to marry you.
I want to spend the rest of my life with you. Will you marry me?
Yes! What the heck? Baby!
Welcome to Critical Thinker, where you'll learn how to become brilliant. We've covered a lot of ground in our videos this far. The system for critical thinking called the Lethal 8. Understanding your audience and goal. The rules of logic, the logical fallacies, and now evidence. I'm dividing evidence into three subjects. Evidence in the courtroom.
We, the jury, find the defendants not guilty of...
Evidence in the crime scene.
He died hours before this accident ever happened.
So our accident is not an accident at all.
And evidence in the laboratory.
Hey there, I'm Jimmy Fallon. Welcome aboard the Gyrosphere, an amazing machine made possible by science. Your safety is our main concern, which is why you're behind our invisible barrier system, which protects you from things like Dilophosaurus venom. One drop of this can paralyze you, so watch out. Is this real? It is?
Each of these videos are going to help you flesh out what counts as evidence in our legal system, in our investigative system, and in the realms of science. By the end of our videos, you'll have a better understanding of evidence and begin to apply what you learn in ways you never thought possible. We have an inability in our society to evaluate ideas. Our culture as a whole doesn't know how to verify or invalidate if concepts, beliefs, and claims are true or false. We've lost our filter for testing truth claims.
But on to Spielberg. Here's a picture of him with a Triceratops. You know, as the extinct dinosaur from his movie Jurassic Park. But not everyone knows that. Spielberg is being shamed for killing that animal. One guy wrote, "I don't care who he is, he should not have shot that animal." Another guy wrote, "Why did he kill so rare an animal?" Then Penelope won't see any of his movies anymore. And there it is. I'll never be shocked by internet stupidity ever again.
The field of evidence will help you test what is true in yourself as well as others. So what counts as evidence broadly? The source for our material on this topic is the U.S. legal system's rules regarding evidence that is permissible in court. Secondarily, we'll be considering how investigators consider evidence. So think courtroom and crime scene. As you learned when we covered logic, most of the logical fallacies have to do with relevance. Are the premises being made relevant to the conclusion? Evidence is considered on the basis of its relevance as well. This is the easiest and most essential element for evidence. If you can stay laser focused on connecting the evidence to the argument being made, you won't make mistakes in your arguments, and you'll help others argue better. In your mind, connect evidence to relevance. Evidence equals relevance. Number one, what's the argument? What is the evidence? What are the facts at play? Number two, how is what they're saying related to the argument? How does it connect? How is it relevant? Reasonable connections relevant to the case are the only types of evidence that are permissible in court.
Show you out of order. I show you out of order.
Here's how relevant evidence is defined. A, it has any tendency to make a fact more or less probable than it would be without the evidence. And B, the fact is of consequence in determining the action. Here are the types of evidence admissible in court. Number one, real evidence. These are tangible things such as a weapon. Number two, demonstrative evidence, a model of what likely happened at a given time and place. Number three, documentary evidence. This could be a letter, a blog post, a social media post, other documents, ancient documents even. Number four, testimonial evidence. This is eyewitness testimony, also called direct evidence. Number five, inference. It is probable but not certain. So we're talking about all likelihood. Number 6, character. They have good or bad character. Number 7, statistical proof. The numbers game. Legitimate probabilities and likelihood of something occurring. Number 8, recurring situations. If a person has performed habitual behaviors, say fleeing from police officers,
Bad boys, what you gonna do? What you gonna do when they come for you?
that would usually procure guilt. A common type of evidence that is inadmissible, meaning irrelevant and unacceptable in the court, is when a trier of fact, say the prosecutor, introduces evidence that is not relevant but damning for the defendant because it produces unfair prejudice. Understand, everyone is prejudiced to a degree. We all have biases and no one's free from influence. That doesn't mean we cannot arrive at objective truth. It just means we must be aware of the biases and influences that could distort our interpretation of the evidence. These prejudices cannot be used to paint a poor picture of the defendant. If it's not relevant to the case being argued, then they have to throw it out. If the defendant is on trial because they did something immoral, then details concerning their character or lack of would be relevant. If a witness is on the stand providing incriminating evidence and the prosecutor accuses them of stealing from a neighbor a decade ago,
And I say, Zangief, you are bad guy. But this does not mean you're bad guy.
everyone in the courtroom should be asking how is that relevant to whether his boss subcontracted a job for the government. If the connections can be made that those facts are relevant, then we have evidence. If the facts, though they may be facts, are not relevant to the case being made, then it won't be counted as relevant evidence, and it'll be thrown out. The difficulty is for the jury to disregard what they now know about the witness's character. They have to guard against judging their character and stay laser focused on what's relevant. Moving from the courtroom to the crime scene, specifically a detective's point of view,
Oh, there's one more thing, sir.
everything is evidence. Everything that was in the crime scene, everything that's not.
But how do you know about them?
Elementary, my dear Watson. This man has been dead for at least 2 hours. Moriarty isn't wasting any time.
Remember the relevant connection for evidence. When investigating something, throw this principle out the window because they are in the process of determining what is relevant. They are investigating. Everything is considered evidence to a detective, and we don't know its relevance until fully explored and tried. When I'm disciplining my children, what they say can and will be used against them, but also what they don't say.
The department was forced to drop the charges because you forgot to read him his Miranda rights. What possible reason is there for not doing the only thing you have to do when arresting someone?
I did read him his right. I did a version of that.
Do you even know the Miranda rights?
Yes.
Let's hear them then.
You got a lot of stuff to do.
Go ahead. You going anywhere, Schmidt? We got time.
I had a thing, but I could probably push it back.
Go ahead. It's 4 declamatory sentences followed by a question for a total of 57 words.
Okay. Look, it obviously starts with you have the right to remain silent. I know you've heard this before. And then, I think it sounds something like, well, the thing, right. You have the right to remain an attorney.
Did you say that you have the right to be an attorney?
You do have the right to be an attorney if you want to.
Where were you?
I was chasing my perp, sir.
And how did that go for you?
Honestly, he did get away, and he threw me down pretty hard.
When I ask my youngest son why my daughter's crying, and he responds because she hit me, is that relevant to why my daughter's crying? It may be if she hit him and she hurt herself, but there's something else going on, and I want to get to the bottom of it. Which is why what they don't say or do can be just as much, if not more, evidence for the truth of the issue. Evidence from a legal standpoint is concerned with proving what is presented as true or false. Evidence from an investigator's standpoint is concerned with everything. From a detective's point of view, everything has the potential to be evidence. From a lawyer's point of view, only that which is relevant to the case is evidence. After this, there are 2 forms of evidence: direct evidence and circumstantial evidence. Direct evidence is eyewitness testimony. Indirect evidence is everything else. We call this circumstantial. Direct evidence equals witnesses. They witnessed an event, an action, a crime. Indirect evidence has a lot to do with the relationship between cause and effect. Why is there blood on the floor, but a spray pattern on the wall? Physics, blood viscosity, coagulation, force, forensics, they all come into play to go from effect to cause. Inferences are drawn and a recreation is produced to explain what happened, according to the evidence. Physical evidence can include anything, such as a weapon, fingerprints, shoe prints, tire markings, tool impression, hair, fiber.
What's that in your hand?
No way, Mom. He was murdered by Colonel Mustard in the dining room.
What's that in your hand?
With the knife.
These kinds of physical exhibits of evidence can be examined and analyzed by professionals who can provide the court with expert opinions. They would try to connect the item of evidence to the person, the place, or the criminal event. This allows the court to consider circumstantial connections of the accused to the crime, or the accused to the victim. For example, in the case where the fingerprints of a suspect at a crime scene and a DNA match of a murder victim's blood is found on that suspect's clothing, forensic connections could be made, and in the absence of an explanation, the court would likely find the physical evidence to be relevant and compelling.
He moves! Right there! Wait! Right there! Right as I'm sitting down! I don't know how he does it. But there's no tack on my stool before he moves, and after he moves, there's a tack. Coincidence? I think not.
Bernie.
Don't Bernie me. This little rat is guilty.
You and your son can go now, Mrs. Parr. I'm sorry for the trouble.
You're letting him go again? He's guilty. You can see it on his smug little face. Guilty, I say guilty.
Guess which one is the most used, direct evidence or circumstantial evidence? By over 85% of the cases in the United States, circumstantial evidence is the one used the most. The vast majority are solved via circumstantial evidence. Which is stronger, eyewitness testimony or circumstantial? Judges tell juries not to give more weight to direct evidence than to circumstantial evidence. Neither is entitled to a greater weight of importance. They're different kinds of evidence, but they should be weighed equally. In 1970, Richard Susskind and Clifford Irving concocted a scheme to forge an autobiography of secluded billionaire Howard Hughes. Assuming that Hughes would never come out from hiding to challenge the book, they felt that their plan was foolproof. Irving went to McGraw-Hill to publish his book, claiming that Hughes had approached him to write his life story, and that he was the only one willing to speak to Irving.
Sir, I wish you would reconsider. What do we tell the president?
Tell him the dream is over. Tell him Howard Hughes said so.
It's the Rocketeer!
As proof, Irving produced forged letters that he claimed were from Hughes. McGraw-Hill agreed, paying him $765,000 for the right to publish the book. When the word of the book was made public, Hughes caught wind of it and contacted reporters to denounce it as false. Not wishing to appear in public, the billionaire would talk to reporters only by telephone. Thus, a spectrographic voice-print analysis, an instrumental comparison of one or more known voices measuring tone, pitch, and volume, was conducted to determine if the speaker was indeed Howard Hughes. Although a handwriting expert had previously been fooled by the notes that Irving had forged, the voice analyst correctly identified the speaker as Hughes.
Show me all the blueprints. 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 I want to get this done right, so show me all the blueprints.
Irving was exposed and confessed before the book was published. He spent 17 months in prison, while Susskind spent 5. Irving later wrote a book about the scheme, The Hoax, which became a major motion picture in 2006 starring Richard Gere. The problem the prosecutor faced was getting Hughes to testify in court that these two swindlers were lying. Hughes was a recluse. He would not be seen in public. So what evidence could they provide to the court that was relevant in proving these authors did not represent Hughes? The forensic science of voice identification helped to serve as evidence that convicted Susskind and Irving. This spectrographic voice print analysis was used as evidence that the reclusive Howard Hughes was indeed the one speaking on the phone, which then enabled the court to accept his eyewitness testimony that the authors were indeed lying about his biography. Most of this has been pretty technical, but you need to know what counts as evidence in the crime scene and in the courtroom so you can begin to harness those same rules in your everyday life. Knowing the rules of evidence will serve you in ways you didn't know possible. From choosing your spouse, to losing weight, from making the case that you're the best person for the job. If you want to persuade people, the rules of evidence will serve you in that goal. If you want to think critically, you can't do it without understanding the rules of evidence. Evidence equals relevant. As you hear arguments being made, keep asking yourself, how is this relevant? How is this relevant? How is this relevant? As you prepare to persuade, go at it like an investigator, counting everything as evidence, exhausting all possibilities. As you cross-examine other arguments, go at it like a lawyer, only counting evidence as relevant to the case being made. Stay tuned for our next video on rules of evidence in the laboratory. We'll be covering what counts as evidence in the realms of science. And until next time, critical thinkers, think deeply.